Before we start asking questions, I want to first thank you for taking time out of your schedule and to come up here and chat with us. We really do appreciate it.
Thank you for the invitation.
You're more than welcome. And to start off, though, I'd like to ask kind of a personal question. And, you know, it's not that personal, but it's personal. In another recent interview, you said that you more or less fell into law librarianship. And can you tell us about that? And what was it about law librarianship that's kept you so engaged?
Sure. So I fell into law librarianship primarily because neither law nor librarianship were on my radar at all in early education. I'm not sure what that says about my early education, but in any case, it wasn't on my radar. And I didn't really think about law until I went to undergraduate, where one of my roommates was pre-law. And it was actually through her influence, I think, that I decided this sounds like an interesting path to take. I went to law school. While I was in law school, I was working part-time at the San Diego County Law Library. And that's where I realized that law librarianship was a distinct track. And it fit me in a way that none of the other professions that I had seen before suited me. I loved the study of law, the discussion of the topics, being able to see any issue from any perspective and to argue that perspective. But I didn't necessarily think that the adversarial approach was the one that I wanted to pursue. And don't get me wrong, there's a lot in law, whether it's alternative dispute resolution or transactional work, that isn't adversarial, but when I went to law school, it was really the adversarial nature that dominated almost all of my classes. So that's what I thought practicing law would be about. And librarianship was a lovely detour from that. I got to use my education in a way that really was just to help people find the answers that they needed. And so I headed down that track. In terms of why or what keeps me engaged in law librarianship, I think part of that has to do with the time that I entered librarianship, which was 1995. If you remember, Mosaic just debuted.
Oh, yeah, yeah.
So the graphical web, law schools, or rather I should say law libraries, were creating web pages for their law schools. Faculty were moving from DOS to Windows. So there was all this transformation happening, and that's when I entered librarianship. And I saw the challenges, but more than that, I just saw the opportunities. Technology makes it possible to do so many more things in terms of access, preservation, that we just couldn't do before. And those possibilities continue today. Every time technology changes, I say, oh, we can use this in a different way. Maybe we can preserve more. And that, I think, is what keeps me engaged in law librarianship.
Well, I think it's true, and I think maybe a lot of people don't realize that librarians and libraries have been kind of taking advantage of technology from the very beginning. And that's a perfect example, your experience, and that draws you into librarianship. Right? I was hoping you could talk a little bit about something you discussed in your plenary this morning, and that's the emerging method or concept of controlled digital lending. And I'd really like to hear about the pilot project that Georgetown, the library center or the law center, is undergoing in this area with controlled digital lending.
So controlled digital lending, even though I've been writing about it only probably about 10 years, I've been talking about it for about 20. And the reason why is, at least in terms of the legal theory, that developed when I was working for the University of Houston. I was helping them rebuild after Tropical Storm Allison. Most of their collection was underground. They lost everything in that collection. And part of my thinking through preservation strategies going forward was, how can we build collections and maintain them, preserve them in ways that will survive natural disasters and still respect copyright? And I came up with controlled digital lending. It was not called that at the time.
What did you call it?
I think it's gone through various...
That's a good question.
Right, I think it's gone through various iterations. Mostly I just called it digital lending, I think. But yes, over time, digitize and lend, we've used all sorts of different terms for it. But at that time I was really just saying, I want to respect copyright, but if a library has acquired a copy, we should be able to find a way to preserve that copy in digital format, lend it out, one copy at a time, because if we own one copy, we should only be able to use one copy. And if a natural disaster happens, your patrons can still access those materials. If you had unique materials that no one else has, you still preserve them for society. So the whole concept of controlled digital lending, at least the legal theory, actually grew out of my work with the University of Houston. How it has developed over time, I think, Internet Archive also about 10 years ago, I think it was in 2011, started actually implementing or lending materials that actually was consistent with controlled digital lending. We had not known about each other's efforts at all, and we actually discovered ourselves through our launching, essentially my writing, at the same time that they were launching their service. How it has developed now is it's just a broad-based view of library collections, and how can we maximize the use of our collections in a way that is intended to meet the Constitution's purpose of public access, public interest. How do we ensure that we have an informed electorate? And the way that we do that is making materials available to our users in an easy, accessible form, and that is through controlled digital lending. So the summary of CDL is it's format shifting. It takes our physical collections, whether that's microform, whether that's a print book, it digitizes it, then we circulate the digital copy in place of the physical copy. We can't use both simultaneously, we can only use one or the other, but that it really is a format shift.
And it strikes me that it preserves the notion of copyright. At least that's how I would interpret it.
That's correct. So copyright doesn't protect, and this is a common misunderstanding. People think that it protects each individual copy of that book. Copyright actually protects a work. That's what copyright is intended to protect. And the fact that what we're doing is shifting the format, but we're using no more copies than we own, I do think is the perfect balance of copyright. It respects the author's interest in that you're not making thousands of unauthorized copies and sending them out there. But it also respects the fact that the library does need to provide access to its patrons in the most usable way possible.
Yes.
So with the Houston destruction, I guess would be the word, you said they lost everything. Was this the law center or the whole library?
So this was just the law library.
Okay, so it's the law library. Was there any way to, I mean, did you have a catalog, and did you say, well, we once owned these books, and so we're going to make digital copies?
So at that time,
Did it provide the answer for that?
It did not. It did not. I mean, it would have had we done
Had you done
beforehand. But a lot of the collection that was lost at Houston was unique. They were materials that were out of print. You may or may not be able to find them in secondhand bookshops, or just unique to the Houston area. Those are the ones that really hurt my heart that we lost, because they just cannot be replicated. Right. So CDL would not have worked in that circumstance because it was after the fact. It only really works for disaster recovery if you do it at the front end.
Now you have to have the copies digitally available ahead of time.
That's correct.
Yeah.
Now, could it work in theory for other libraries going forward? If enough libraries adopt controlled digital lending, so they have digitized the titles that were in a collection that's lost, then yes, I actually think CDL could help that library in saying, you owned a copy, you can prove you owned a copy through your library catalog, so you can use a digital copy. So I think that it has the potential to do that. It just hasn't gotten to that stage yet.
Well, I'm still so intensely interested in this tragedy of the loss of the library. What did the library do to recover from that? I know we veered away from
It's
controlled
quite
digital
that's a
lending,
good question.
We were very lucky in terms of FEMA. FEMA provided a significant amount of funds, not only to rebuild the physical library, but also to rebuild our collection. So through a series of years, they might still be going through part of that process, they looked to replace as much of their collection as they could. Even if it wasn't with exactly the same title, FEMA was generous enough to say an equivalent title. So if we had a strong collection in environmental law, if we couldn't replace what we needed, we could find an equivalent title and replace it with that.
And the University of Houston's not the only library that's had this kind of an experience. Libraries out in Colorado and other places have had similar experiences.
That's correct, and the number of natural disasters is increasing every year. Climate change is affecting it. The fires in California, earthquakes, tsunamis, pretty much anything can cause a library's collection to be decimated, or even if not decimated, inaccessible for a certain period of time. Again, controlled digital lending gets around all of that, because regardless of where you are, you can still access that collection.
I'm just going to finish with Houston in a minute. But the copies were so wet and pulp that you couldn't even freeze dry anything and take apart the pages, nothing.
So the majority of the library was underground, and they got, I think, 18 feet of water. So essentially it was all underwater. And because it was underwater, no one could actually come in to retrieve the works for a number. Right. So they were destroyed. I would argue even once they got to, even if they could have gotten them to immediately, I'm not sure they could have freeze-dried
Yeah,
them.
yeah.
The materials that were on the upper floors that were not directly touched by water, mold got into everything. So we often joke that microform will survive anything. It did not survive that flood. So you looked at the microform afterwards, even the images did not survive.
Wow.
Yeah.
So in your lecture this morning, you took us through some more, well, you didn't have enough time to be thoroughly rigorous, but the fair use arguments that advance controlled digital lending. Can you spend a couple minutes on that?
Sure. So controlled digital lending is very different from any other example that you can find of a copyright case that's out there right now. And a lot of that is because most of the time when you're looking at copyright infringement, you're talking about someone who never purchased a copy of the work. They just want to use it for a particular purpose. So controlled digital lending is very different in that libraries have already purchased the item, or they've been gifted the item, and all they want to do is use it as technology changes. So to give you an example that's not about a book, but let's say you have a movie that's on film. Buying the content over and over again in Betamax, then VHS, then DVD, then Blu-ray is not actually the best use of a library's money, because you're paying for the content, not just the container. And so CDL, in its rawest form, is a recognition that technology changes, but if copyright is intended to protect the work, then libraries should be able to use the copy of the work that they've acquired even as formats change. And that might mean that libraries have to transform that work. The fair use analysis really comes down, we think, to factors 1 and factors 4, which are the ones that the court pays the most attention to these days. Factor 1 is the purpose of the work, or the purpose of the use. And in a library's case with CDL, the purpose of the work is exactly the same as the print copy that we purchased in the first place. We just want to lend it out to our users to have them use just a completely different format. And we think that both respecting the ownership and loaning ratio, ensuring that you never lend more than you own, is a very, very different purpose than, again, any other copyright infringement case that you'll see out there. Usually that's a proliferation of copies. In terms of market effect, we think library ownership also makes a difference. So the market effect, as I stated during the presentation, copyright isn't intended to protect against every market impact. There are any number of market impacts that copyright says, that's okay. That's actually the market working the way it should. And the example that I gave is if I write a scathing review of a book and sales plummet, copyright doesn't protect against that, even though it has a clear market effect. What copyright is supposed to protect against is unauthorized copies, which take the place of unsold copies on the market. So essentially, someone's using an unauthorized copy instead of buying the book. And our argument is libraries have actually already purchased a copy of this book. And when we digitize and use that digital copy, it doesn't replace an unsold copy on the market. It replaces our copy that we've already purchased. And so for that reason, there actually is no greater market effect than just using our print book.
So I suppose any objections from copyright owners would be about the fact that you digitized it and made another copy, even though you're only using one. How do you talk about that?
Sure, I think that the major objection is that the digital form, it moves faster than the print form. So more people can have access to that work. When a work comes back in print, you might have to wait for it to be placed on the hold shelf, to notify the next patron, for the patron to come to the library. So that book might touch fewer patrons. And what I'll say is, they're absolutely right. Technology does ensure that there's more efficient use of the work. But I don't think that it was intended to be protected by copyright.
But we're making an unauthorized copy, they would say.
And I would say that's true, but the whole concept of fair use is where the government has said, or Congress has said, that this use is so much in the interest of the public that it overrides the author's rights. So it's fair use recognizes, you're right, an unauthorized copy has been made, but we're going to say that's okay. So what I'm saying is, yes, we are making a copy, and yes, we are doing a distribution, both of which are typically exclusive rights of the author. But what I'm also going to say is, because we're using that to replace something that we have actually purchased, we've already met the author's interest, and now it's more about the public interest. So there is no point at which I'll deny that a reproduction is being made. I absolutely think it has been. It has been. Or a distribution has been made. It actually has been. I just think it is a legitimate use based on fair use.
And to be clear, that this hasn't been determined in case law yet.
No, there's no, because it is so unique, and because libraries really are the only ones who can claim this sort of right, it has not been discussed in courts. And there's no similar case law that could be brought to bear.
Does the HathiTrust case help you at all?
HathiTrust doesn't, because they don't, with one narrow exception. So they circulate, they can give the full text of their works to print-disabled users.
Right.
But we're saying that the right to circulate a collection actually belongs to not just print-disabled users, it belongs to everyone. So that's, it is distinct from what HathiTrust was trying to do.
Yeah, interesting.
Yeah.
So laws generally or always lag technology developments. And we see this all the time. Does that, I know for you it makes your work much more interesting and it keeps you in the profession of law librarianship, but is it also, can you think of ways in which that's really vexing and problematic?
Absolutely. I mean, it is, well, it makes it interesting for me. On a day-to-day basis, it is enormously frustrating. So just to think about it, both the Google Books case, the Redigi case, almost any case where you're dealing with copyright and technology, by the time the last court rules, that technology could be 10 years old.
Yeah.
So they're not even talking about today's technology. They've resolved something that's not even being used anymore, which is, I think, why whether it's universities or libraries or nonprofits are so conservative about how they use copyright. It's because it's so unpredictable. You don't know what the court's going to say, and when you get a ruling, you're not using that technology anymore. So it's, for me, it's enormously frustrating because it does mean that a library that wants to push those boundaries and say, we want to present something that's within the spirit of copyright law, even though it's not explicitly laid out, something that's within the spirit, so within fair use, you really do have to convince all of your counsel's offices, you have to persuade them that this is something that is legitimate and why it is legitimate. It just makes it harder for libraries to do what they traditionally have been able to do without question in the past.
Well, I really appreciate your point about the long time it takes for cases to wend their way through one level of court after another. Also, I remember, I think it was when Justice Pierre Laval, back 20 years ago, made, and I don't remember what the ruling was called, but anyway, there was a lot of criticism then, or comment then, from the library and technology communities, that the people who are hearing these cases are not themselves familiar with the technology and really don't know. I don't like to say they don't know what they're talking about. They know about the law, but they don't know about the tools because they themselves are not users. And if you're really looking at this kind of time lag of 3, 5, 10 years, that's going to be true of the judiciary who are sitting in these high-level courts hearing these cases, right?
That's absolutely true. I do think there might be, interestingly, if just in the recent cases, a slight advantage in that delay. You're absolutely right. I do not think judges are the first adopters of new technology.
Yeah, right.
But 10 years out, they may have benefited from it. The Google Books case, I absolutely believe that the reason it came out the way it did was because judges had a chance to see the impact before it reached them.
Interesting.
That they had a chance to use it themselves, and that it made sense to their everyday lives. It wasn't just this theory out there, that they actually got to see how it played out. So I would say, at least in recent years, I actually think the delay may have helped in some ways, at least.
Well, and then I remember we used to hear that, you know, these judges have clerks, they're younger, they may be familiar with the technologies and so on and so forth, but that seemed to me it would depend on who your clerk was and what their point of view was, even if they were only, 23 years old.
Unless it's very popular technology that is broadly adopted, regardless of your age, you might not use it. And some of the technology that comes before the court is very technical, with antennas and how that's rebroadcast. I don't think that anyone, however, whatever their age is necessarily naturally going to know about that.
Right.
Given the state of copyright law, do you see any threats to interlibrary lending and fair use? And are there any trends that librarians should be aware of?
So I'm actually not too worried directly about the impacts of copyright law. I am very, very concerned about the indirect impacts. So we've seen a trend among publishers, most recently reflected in Macmillan and Amazon's decisions, to try to restrict libraries' access to just information. I do worry that publishers and vendors are going to try to circumvent copyright law entirely by entering into contract arrangements with libraries where libraries can never own information. If you never own information, then does first sale ever take place?
You're not protected.
That's
You're
correct.
just not
That's correct.
protected.
You might be violating the contract, even if it's within the normal bounds of copyright. That worries me tremendously. Now, what do I think will hopefully balance out the scale if publishers continue down this route? Two things. One is antitrust. I think with Macmillan, with Amazon, the question of antitrust has been raised and is being explored by Congress. I also think that the actions may get so difficult to overcome that libraries or their counsel's offices may be willing to push back on contract and say there was this approach with contracts where when clauses were considered unconscionable, they were so against the public interest that those clauses could be stricken from the contract, that they cannot bind the parties anymore. Do I see it possible for us to be heading down that route somewhere in the near future? Possibly. Because if it comes down to we're restricting information from ever reaching libraries, then I think the question becomes, are we actually undermining the Constitution? The intent of the Constitution was to enable people to have information, to be an informed electorate.
Yeah, definitely. I mean, that's something that we do need to be concerned about. I mean, and publishers will try to protect their profit margins and so on, which they have every right to do and should be doing.
That's their job, right?
Exactly, exactly. You've also been interested and very concerned about open access, and you have argued that law libraries and law librarians in particular have a duty towards open access. And I was wondering if you could expand on that and tell us why you feel that way.
Sure. A lot of it is tied to the content of our libraries. The other reason why I think law libraries and librarians have a greater responsibility is because of opportunity. So I'll explore both of those. In terms of the content, they're laws. They're the things that bind the people who travel through our country, who live in our country, who are citizens of our country, or states or territories. And because they bind people, those people should have access to those laws. Complete open access to those laws. To take that a step further, the text of laws are now, in some cases, so detailed and difficult to understand by themselves that secondary sources are also needed for people to really gain access to their laws. So for all of those reasons, I think law libraries do have a greater obligation to try to make people understand the laws that they're governed by and why they're being governed in that manner. The second reason we have a greater obligation is because of opportunity. There are some unique aspects of law libraries that I don't really think exist elsewhere that I think make it more possible for us to push for open access. The first is that a lot of our literature, not all of it, but a lot of our literature is published by law reviews that are owned by law schools, and therefore there are fewer copyright issues. I'm not going to say there are no copyright issues, because obviously there would have been agreements with the authors, who owns copyright, what are the limits of that, but clearly the law schools have the copyright to a collective work, and they should be able to publish it and make that generally available. So I think in that manner we have access to a few more tools when it comes down to taking a look at the materials that law schools themselves produced and publish. The second reason is, again, because of the type of materials that we work with. So as we do research for our users or help our users do research, many of the materials that they're looking for are government works that are just hard to find. So they're buried in the National Archives. Right. They are an unpublished decision of the court. They're just difficult to find, but they are public domain materials technically. So once we help a patron obtain them, we have the ability to ask that patron, after you're finished publishing your article or paper, do you mind if we make this publicly available? And through those steps, we can actually slowly but surely start making more government information available that the government either doesn't have the time or resources to make available themselves.
And you're building a database of digital content.
And we're building a database of digital content. One such example at Georgetown is we just built a foreign intelligence collection. Many of the materials were gotten only through FOIA requests. So again, they're publicly available information, but you have to have the time and resources to
Right.
file and get those materials. And once we got all of it, we talked to the professor and said, do you mind if this is turned into a database? She didn't mind at all, and it was published and available now.
So is this a collective thing that law libraries are doing together, or are they individual, I'm going to say uncoordinated actions?
I would say for the most part they're uncoordinated, but they're not all uncoordinated. So there are certain types of topics, for example, American Indian materials. Those I do think there are collaborative efforts on. The Japanese or World War II internment issues, I do think that there is collaboration on that. But overall, if you look at all law libraries, I'm sure we're all doing many things by ourselves as well.
So you should have a kind of cross-finding
Central.
aids project or something like that.
Absolutely.
Last year, one of our keynotes was by Ruth Okadiji from Harvard, who's a force of nature, like all law librarians are. I'm coming to realize.
It seems that way.
It's one of the qualities that you all possess. But towards the end of her talk, she expressed concern about the role of librarians that librarians are taking on. And yesterday, in a much smaller session, she took that a little bit further as a kind of, it wasn't that librarians are failing, but it's somehow that the setup with copyright law and technology, whatever, contracts puts us in a position of failing. I think she finds the role that many librarians take on, you know, a faculty member coming to the office and saying, Mother, may I do this, may I do that, and the well-informed, you know, articulate librarian says, well, given the XYZ, the nature of the 4 factors or the nature of our license or something, you can't do this, but you can do this. And she really feels that librarians are increasingly being put into a role as copyright police people, and she thinks that's wrong. I mean, I agree that if that's what's happening to us, it's not a good place to be. But then my question to you is, if you agree at all with any of that, how would we get out of that bind? It seems really hard.
It is very hard, although maybe not quite as difficult as has been phrased, because librarians, in most cases where you have librarians who have law degrees, they're not practicing law. They actually should not be making a ruling about what actually is and is not fair use. What they can say is, based on my personal analysis of these 4 factors, I think this is safer or not. Like, they can make that analysis unless their job is actually as a copyright librarian. And we do have a number of those in any number of universities where there is a specific role where that is their charge. But I actually think the softer role is much more useful for universities, where they can consult someone who is familiar with the law, but who is actually not going to outright tell them what they can and cannot do. That really is for counsel's office to say what they can or cannot do, what the university is willing to defend and not defend. Libraries should educate. I think that is part of our role. I think oftentimes we do know more about fair use than maybe a given faculty member, and we should inform them of that, but I don't think we should make the choice for them.
No, and I didn't hear Ruth arguing that we're making choices for them, but that more and more we are put in a position of dealing with copyright and contractual issues rather than taking some other kind. I don't know if it's a high ground. I think what she wants more librarians involved in is actually the process of you know, adjusting, advancing, creating new laws. And I don't know where that happens except maybe in lobbying organizations like ALA. So I felt really powerless when I heard, you know, her describe what I think, you know, I've done a lot of, and I said, well, how do I make a difference?
Right. Right. I mean, I do think there is a place for advocacy. I do think, especially when it comes to law librarians, most of us have law degrees. We actually should be pushing the edges. We should be saying, let's not tie our own hands. Let's not do the authors or the copyright owners work for them and say we can't do something if we actually think we should be allowed to do so. If we think fair use allows it, if we think the statute itself may be outdated, it's dealing with old technology, we should be fighting with our counsel's office for a more reasonable interpretation of that law and seeing if they're willing to work with us on that. I actually think if we're willing to actually engage in that discussion, we might get a lot further than if we start at the front end and say, oh, no, we can't do that. Or no other library has done that, we're not willing to go down that path. Like if we're willing to engage in that conversation, we will get a lot further.
Well, I think Ruth yesterday and you today are sort of pointing us to a better way, and we have to figure out how to actually take that better way.
Well, I like the word advocacy, because that seems to really encapsulate what we ought to be doing, especially folks like you who know libraries and the law.
And I think it's very tied in. We are one of the few, libraries are one of the few organizations that has a primary mission of trying to meet the public interest when it comes to we are really the only ones who can advocate effectively for the public interest, so we should be doing so.
Yeah, fair enough. So this morning in our session, we touched a bit on privacy.
Yes.
A terrible topic these days, and I think for libraries it's very complicated because apart from defending and protecting our users' privacy, we also do gather a lot of data, inadvertently or not, which could be harnessed to improve services and so on. And do you have any thoughts about how librarians would position themselves on that privacy versus service continuum?
Sure. First of all, when it comes to vendor services, not necessarily library services, what I'd say is I don't think libraries can do anything to protect against that. I think we can argue for the best negotiation of licenses, but at the end of the day, the individual user has to decide whether or not it's worth giving up their privacy for the content. I don't think the library should be stepping in and making that choice for them. I do think it is incumbent on us to tell them that, though, that they are making a choice and that someone else is using their information. Where it comes to library information, or library collected information, it becomes much harder if the library doesn't realize it's collecting it. So if it's using, for example, the servers of Amazon or someone else, and it is for whatever reason unfamiliar with their rules, it becomes much harder to do that. But I think where the library does know that it's collecting information, so for example, it has a record of every patron's name and address, at least in theory, user card number, it would have all of that information, and it collects it for a very, very specific purpose. I think we should make sure that users know we're collecting it for this purpose. We don't keep some libraries may, we don't keep a record of what they've checked out. It is just automatically deleted through the system, but it does keep a record of the last person who checked out any given book, right? So just being aware of what your systems collect and being able to explain that to your users is useful. But overall, privacy is such a hard issue because I think most of the very troubling behavior I've seen is actually not by the library. The libraries aren't the ones who are capturing the information. It's being captured by an outside entity who's doing all sorts of analysis and can be using it for other purposes, and we have no control over that.
So you don't think the library needs to worry about having students sign waivers or anything like that?
I don't think so, unless the library is collecting something really unusual for a specific purpose. So for example, if the library is intentionally collecting data that it normally doesn't collect to evaluate a service or to determine if there's a need for a service, then I think it has to disclose that as it's collecting information from its users.
I'm just trying to think through this. I mean, often, we've all licensed and negotiated and blah, blah, blah for electronic resources that are important to our users. And we put in a clause that says, privacy shall be respected, so some better formulation of that. But we really don't know what's going on with different publishers, and it's not so much their intentions. They may, honestly sign off on things like that because they believe in privacy, but they have all these other relationships with third and fourth party and downstream providers and so on. So I think often librarians, however well-intentioned, just don't know if downstream there is information collected, number one, that's not retained, number two, and that hasn't gone to other parties who are service suppliers. So I'm almost starting to feel as though we need to tell our users that they need to beware of using any electronic resources from outside because we just don't know.
Sure, and users, even just browsing the web, you're being tracked like every moment of the day, right? So I actually think that's a good, I shouldn't say good, I do think that's a new part of how libraries are actually teaching how you do research. Just be aware that at any given time, whatever it is that you're researching, unless you're on a VPN that's owned by you, like is or may be viewable, and just to be aware of that.
It can be tracked, and you just have to understand that that's part of the modern world. Yeah.
And you know, there are a lot of people who are fine with that. I mean, there are people who are happy to have video cams in their bathrooms or whatever.
Right, absolutely.
But you know, there are a lot of people who say, oh my God, if I could go live on a mountaintop in Montana and never see anyone and never deal with currency or anything again, that's what I want. And you really have to be mindful of the whole continuum of the kind of users you have.
You're right. Yeah.
And to let them know how they get to that option. I mean, you could move to a cave and not have access to anything, but that also means you won't get Amazon deliveries, and you won't get
exactly.
So all the things that you consider part of the convenience of your life, you might lose that as well.
Yeah. That's the double. Oh, go ahead. I'm sorry.
No, I just think most of us have kind of given up on that.
Yeah. It's kind of a double-edged sword, but you know, there's so much that you benefit from. You're willing to make some sacrifices. It seems. Katina Strauch, the founder of the conference, wanted me to make sure that I asked you if you wouldn't mind speculating on something that she's interested in, and that's the EU's General Data Protection Regulation and how it might affect U.S. and other international libraries. I was wondering if you could speculate a little bit on that.
Sure. The part that concerns me the most is the right to be forgotten. I think that's what we spend a lot of time talking about. And it's actually the indirect impact on librarians, not necessarily the direct one, because there are a lot of exclusions in the right to be forgotten, where libraries and their interest in preservation is considered an exception. But there are some unintended impacts of the right to be forgotten, and I'll do this through illustration. My understanding is there is an Italian journalist who wrote 10 years ago about two brothers who got into an altercation and did some physical harm to each other, although I don't think any was lasting. Since the right to be forgotten has come into law, he's been told that he has to take that down because it disparages or sends the wrong message about these brothers, despite the fact that it was based on a police report, something that was completely factual, despite the fact that there is no denying the actuality that this happened. At the end of the day, he might win his suit, but I believe he has gone bankrupt or is going bankrupt because of the costs. So the practical effect of this, and this is what I'm afraid of, is even where exclusions are written into the right to be forgotten, that it will become so expensive to defend it that people who publish will say, it's just easier to take out that information. And then my questions for libraries, who are the consumers, is, especially if we're moving to licensing where we don't own the information, we may not be able to preserve it, is, do facts just start disappearing? Do we no longer have an accurate record of what has happened in the world? That concerns me greatly. I don't know how that case is going to turn out. I suspect the journalist might indeed win, but again, what is that win if he lost his entire livelihood and his savings in the process? I don't know what message that sends to other people who fit into an exclusion.
Well, it has a real implication as to what we think of as history on down the road.
Absolutely.
I mean, if these facts disappear, then the historical record has been tampered with.
That's correct.
Yeah.
That's correct.
Michelle, before we let you go, I do have one final question. And this is an attempt to make sure we didn't miss anything. But if you were sitting in my chair or Anne's chair, what question would you ask yourself?
Or what would you like to tell us that you haven't already told us?
Yeah, that's a fairer way to put it.
Well, it's just a restatement.
I don't know. It's been a pretty broad-ranging interview. I think you've actually covered everything that I would want to be covered.
Well, great. Again, I want to thank you for coming up here and chatting with us, spending the time, and it's really been enlightening and a lot of fun. I've really enjoyed it. So thank you very much.
Thank you. It's been enjoyable for me as well.